money, we have also put in the proof of payment, which is marked as an annexure in the new affidavit, which has been filed on 24th. And as per the instruction I have received, as on date, there are no bills pending with the Treasury, Your Lordships.
In the 24th August affidavit, my Lordship, may I just place para 46. By the affidavit dated 24th August 24, it is stated that information was received by the state from the High Court regarding disbursement of allowances. The High Court has stated that sufficient budget has been allocated by the state and the payments are being processed by the High Court as per submission of bills. A chart prepared on the basis of the information received from the High Court is annexed at page 702 of volume GG. The chart indicates that arrears in respect of 4 allowances are in the process of being paid: concurrent charge allowance, higher qualification allowance, telephone facility, and hilltop area allowance. These are not being paid, my lords. The Judges Association also say.
Your Lordship, with regard to those 4 allowances, whatever bill has been put on, so till date has been cleared. So as and when the bill will be put up, the same will be cleared.
The Lordship, just grant them 4 weeks and ask them to clark these 4
appearance note, sir. In its affidavit dated 24 August 2024, the state of Chhattisgarh has stated that information was received by the state from the High Court regarding the disbursement of allowances. Let's stop. The High Court has stated that a sufficient budget has been allocated by the state and payments are being processed by the High Court as against the submission of bills. Let's stop. The amicus curiae, however, states that it appears that arrears in respect of 4 allowances are still in the process of being paid. The bracket charge allowance, higher qualification allowance, telephone facility, area allowance, bracket. Learned Counsel, appearing on behalf of the state of Chhattisgarh, states that that payments would be made as soon as bills are received. Full stop. We direct that the exercise be completed within 4 weeks.
Your Lordship, the payments has been made. Any further bill which will be put up, the payments will be made.
Learned Counsel of the state of Jharkhand stated that while payments have already been made, any further payments which remain due would be made within a period of 4 weeks of the receipt of bills. The statement on behalf of the state of Jharkhand is accepted. Chhattisgarh is accepted. Compliance be effected in the above terms. The Registrar General of the High Court shall monitor compliance, and in the event that there is any further difficulty, bring it to the notice of the committee of judges constituted by this court by its order dated 4 January 2020.
Your Lordship, personal presence of
yes, we are closing it. Yes.
Exempted.
Yes.
Please oblige.
My lords, I'm very sorry to interrupt. My lords, in case of Andhra, the presence of the Chief Secretary and Finance Secretary may be recorded.
Yes, we already closed it.
It may be recorded.
Yes.
Obliged.
That's a standard order for all states where we are recording compliance.
Assam has not paid a single paisa for his allowances.
Lordship, the notification, Lordship, has been issued on 12th of August, and then Lordship on 16th of August. It's also noted in the note of learned amicus. On 16th of August, Lordship, the entire budget has been made available.
Nothing.
It's Lordship now. For the DDOs, Lordship, there are 204 DDOs who are basically, Lordship, in the High Court and in the subdivisional courts, Lordship. Whenever, Lordship, the bills will be raised, Lordship, within 4 weeks, Lordship, we can make the payment will be made. The funds are available, Lordship.
To contradict, not a single paisa has been disbursed.
This is not good enough. But Lordship, the
What
funds are
we will do
available.
is, we will keep it after, you first tell us when are you going to,
Money, color of money.
when is the money going to be disbursed?
Lordship, the money is made available, Lordship. It is now the process that happens is that the DDOs, Lordship, will raise the bills, Lordship. As and when they raise the bill, within 4 weeks, we will disburse the money, Lordship. The money is available. Even in the note of the amicus, Lordship, it is needed.
They say.
Where is, you said that the budget is being made available. Where is the money lying right now?
It's not done.
Have you transferred it to the treasury?
Lordship, the money will be,
Have you transferred it to the treasury or not? For the purpose of disbursement,
No.
where is the secretary? Where are they? Ask them.
Has the money been
Ask them.
transferred to the treasury, sir?
Then make a statement accordingly.
When?
Then that's all right. Then we'll,
When?
state of Assam, parents note,
When?
Learned Counsel appearing on behalf of the state of Assam
Only on
and the chief secretary.
and the finance secretary, both of them are present, Lordship.
States that on 12 August 2024, a notification has been issued by the state government, and necessary budgetary allocations have been made on 10 August 2024. However, it has been stated that there are 204 drawing and disbursing officers, the state, and as soon as the bills are received, payment would be made
Within 4 weeks.
within 4 weeks.
My lord,
You can say the same thing.
my lord, I'm representing the Assam Judicial Service Officers Association.
Yes.
Although the notification has been issued on 12th of August, my lord, so far as the risk allowance is concerned, they have confined it only 10% as against entitled 30%. That may be, my lord, the recorded, because we are entitled to 30%.
Direction for
The
30%.
other criminal employees are given
There is no direction
30%.
for 30%.
Anyway, if they have a grievance, they can move the High Court.
Yes, Lordship, let them.
This is an overall thing we'll close here. Yes.
That may be recorded in the order, my lord, that in case of any grievance relating to the percentage,
We are
we
not,
may move the High Court.
of course you can. By a previous order, therefore we have constituted that committee.
My lords,
Yes.
at the end of this
Lordship,
order, just reiterate that portion because we are
Any other remaining portion?
flooded
What are the
with,
remaining issues?
Just remind us before we close.
we are being flooded with these individual monod allowances where there are tweaking. So your lordship may clarify it at the end.
Lordship may dispense with the appearance of the chief.
Yes, yes, of course.
Obliged. Obliged.
Keep this.
As far as Nagaland is concerned, page 12, they said the affidavits, the latest affidavit of 16th August said that they've actually cleared. But there is a paragraph there which I've extracted at that para 51 of my note. It is however clarified that this amount does not include pension, family pension, and pension areas to the retired judicial officers. If your lordship just clarify.
Your lordship, the amicus has circulated a questionnaire where we have given proof where it has been given. Now, in the state of Nagaland, insofar as the pensioners are concerned, it goes to the treasury directly from the accountant general, which is why we are not being able to give the exact amount, how much has been disbursed. That is the only clarification that we have given. Otherwise, the proof has been given that the pension as well as the arrears have been paid.
Pay areas, allowance areas, all that has been cleared. Only pension, I think, because of this problem, because it's directly being transferred, they were not being.
I am representing the Nagaland Judges Association. One of 3 allowances are not being given. Number 1, risk allowance is not being given.
Which one?
Medical risk allowance is not being given. They want clarification on that.
Para 53 minutes.
Your lordship, we have filed an application insofar as the
Seeking
risk
clarification.
allowance is concerned.
All other states, northeastern states have been given the risk allowance. Why not the Nagaland?
Your lordship, we have filed an application. Our application is at page PDF 238
Yes.
of the volume GG that the amicus has circulated.
Because there are 2 applications that Nagaland is filing. One, your lordships in your lordship's order of 4th January 24 said that risk allowance is given for posting if the same allowance is being given to other civil servants. So the state of Nagaland now says that its civil servants, although it's an insurgent affected area in some parts, its officers are not getting, civil servants are not getting it. So therefore judicial officers are also not entitled to get it. Your lordship's order was very clear. That
Very clear.
officers will be entitled at a rate applicable to civil servants. So if civil servants are not getting it, and that's the standard of the state of Nagaland, then therefore judicial.
We have annexed the opinion of the AG also.
Then if they are not, if civil servants are not getting it, then the.
Yes, your lordship, that is why the clarification has
As far as
been
risk
filed.
allowance is concerned.
No, my lord, your lordship will kindly make an inquiry. The civil servants are getting the allowances. So far as the All India services are concerned, they are
I'm going
getting
to
it
what
at the rate of
the state is
30%.
Your lordship, I have annexed the opinion.
That will be a misleading fact, my lord.
This issue may be left to the committee and then your lordships will have a view on this. Otherwise, this application, clarification, there are 7, my lord.
Well, let it be
There are
sent
2
to the
other
committee.
allowances, there's a problem with it. Now, if your lordships are to go into all 3 allowances here, then this entire business of the committee will, my lord, this IA for clarification, the committee will look at and decide about these 3 allowances.
Your lordship, may I be
There-
permitted to submit?
Find some solution. The state of Nagaland, in its affidavit dated 16 August 2024, the state of Nagaland has stated that arrears of pension have been cleared, semicolon, full stop. Moreover, amounts of rupees 4 crores and rupees 9.32 lakhs have been released on 15 July 2024 and 25 July 2024 for the payment of the arrears of allowances. Stop. So far, the state has made payment up to rupees 10 lakhs, right?
10 crores, your lordship.
Is it 10 crores? In your para,
I think my zeros, I would have losses. Just
Your Lordship, it cannot be 10 lakhs.
state has made payments of
0.5.
of rupees 10 crores.
Yes, Your Lordship.
However, the state has indicated that however, the state has, however, the further statement is in the following terms. Colon, ये इनके नोट में para 51 में ले लीजिए.
Order dated 4/1/24. That's 10 crores, Malas.
10 crores. Yes.
My mistake.
No risk allowance. Learned Council appearing on behalf of the state of Nagaland states that no risk allowance has been sanctioned for the reason that the civil servants are not receiving it.
Yes, Your Lord. In fact, this issue was brought up with the.
My lord, that
committee
is
as
not correct, my lord. May I clarify that position is not correct.
The moment you start speaking, you will start retorting. So we'll find an answer.
Your Lordship, the committee had.
Discretion lies in just keeping quiet. We are protecting you. Just 1 second.
Okay.
The statement made on behalf of the state of Nagaland is, however, disputed on behalf of the judicial officers. Is disputed by Mr. B.K. Sharma, Learned Senior Counsel, appearing on behalf of the judicial officers of the state of Nagaland. In order to obviate any difficulty, we leave it open to we direct that the committee of judges constituted in pursuance of the judgment of this court dated 4 January 2024 shall verify whether the payment of risk allowance is being made to civil servants. Full stop. The order of this court clarifies that payment of risk allowance shall be made at the same rate as is paid as is made to civil servants.
Civil service.
Para 68 and 69.
My lord,
Your Lordship, may I pray that
My lord,
you
may
make
we
it clarify.
permitted
In
to
case
point
there's
out
no
two more
payment,
things.
then the state will not be required.
Whether any risk allowance is paid to the civil service officers in the state of Nagaland is a matter which should be verified by the committee. Full stop. In the event, it is clarified that in the event that no risk allowance is paid to civil service officers, there would be no obligation to pay to the judicial officers.
my lord, may I point out, my lord, two things, my lord. Your Lordship may edit, my lord. So far as the medical allowance is concerned, reimbursement, etc., has not been mentioned in the order. As to how it will be reimbursed, nothing has been mentioned. And so far as the higher educational qualification allowance is concerned, they say it will be only one time. If I am LLM, I'll be entitled.
Mr. Sharma, please read our order. Therefore, we made a provision for the disbursement of medical allowances and medical treatment.
So there will be a standard operating
They
procedure.
are silent, my lord, about the reimbursement, etc. They are silent.
You go to the
And
High Court
secondly,
for
higher
that.
educational qualification, they say it will be only one-time increments. Subsequent promotion, ACP, etc., will not get any increment. Their notification says so, my lord. Is it so, my lord? That was not the intention, my lord. Your lordship is clear enough.
They say whether a judicial officer is entitled to grant of advance increments for acquiring higher qualification during every promotion or grant of ACP.
Yes,
So that's also covered para 40.
that they have denied, my lord.
If they have denied, then that must be challenged, fellows. What else can I say? Because your lordships,
Well, like, in the event that there is any further difficulty in the disbursal of the arrears, in the disbursal of advance increments for acquiring higher qualifications, this may be drawn to the attention of the committee of judges constituted in person for the order dated 4.
Your Lordship, may I just place on.
Including the
This
medical allowance
actually
issue,
was
my lord.
brought-
Medical allowance issue also.
I have
including the
annexed
medical
the
illness.
minutes of meetings dated 5th August 2024. This was discussed. They were not able to resolve it, which is why the finance had actually written to the registrar saying approach this honorable court for clarification. The issue is this, Your Lordship. Your Lordship direction says that 3 advance increments should be given once they acquire a higher qualification and +1 if they get a doctorate. According to us, we've already given that. Now, what the officers are saying is that every promotion, they should be given that 3 increment again. This is a controversy, Your Lordship, and this is a genuine obstacle that the state is facing because we have already given.
We have already given it.
Yes, Your Lordship.
They are now saying that for every
Promotion, they need to be given.
The normal increment, my lord, not the additional increment, normal increment. They say that once you are given 3 increments on attaining the higher educational qualification.
Granted the first ACP. And at the first ACP, all their colleagues are entitled to 1,000 rupees. I'm just giving an illustration. The advance increment is 100 rupees for higher education qualification. So they get 1,100 instead of 1,000. Now the next ACP, my lords, they are all placed at 1,500. So the officers who are claiming this higher education allowance now say that our edge is lost because all of us in the next ACP have been put at the same bracket of 1,500.
1,500.
So we should get it 1,600 also at that point of time, because we have actually worked and earned an LLM and a PhD degree, so that we are entitled to the advanced higher education qualification advance. So ACP is almost like a matter of, because they are otherwise not promotional opportunities, almost as a matter of course. So they say this edge is lost. Every 5 years we are granted the ACP, because then all of us become par at the next.
It's a one-time payment.
Yeah, that's the opinion of the finance department.
No, the judgment is very clear. Judgment says that advance increment.
One minute. Your Lordship, just kindly just see the judgment para 41 to 41.
That may also be gone into by the committee then.
No, in this case, she is right when she says that the committee has gone into it. They were not able to resolve it. Therefore, they have filed.
Let's see what paragraphs 41 to 43 say.
Yes.
41.
This matter gets resolved.
Para 41 on this is there. The SNJPC noted that for acquiring higher qualifications in law, specialized study of the subjects concerned is involved, and the acquisition of such qualification, the nature of a postgraduate or doctoral degree, will improve the quality of work of a judicial officer. The recommendation of the SNJPC are summarized below. The para 42. The recommendations made by the SNJP is that the benefit of advance increment shall not be extended at the ACP stage appears to be covered by this order of this court dated so and so, so and so. There is no justification for denying the benefit of advance increments at the ACP stage. The object and purpose of ACP is to prevent stagnation. On the other hand, the object and purpose of advance increments for acquiring higher qualifications to improve judicial performance. Hence, the restrictive condition imposed by the SNJPC in regard to the non-extension of advance increments at the ACP stage is not accepted. The advance increments for acquiring higher qualifications shall also be made available to officers who have acquired the degrees through distance education.
So we said even at the ACP stage.
Yes.
For the clarification now, they get first ACP, they get it. Second ACP level at 1,500. So at that time also they must maintain their edge.
Different states are interpreting it differently. So, my lord, I suggest we will just collate it and give it, because this is not a problem only related to this state. Different states are doing it in a different fashion. So this is a problem across the board.
Promotion also it has been.
As regards the grant of advance increments for acquiring a higher qualification, Learned Counsel appearing on behalf of the state of Nagaland states that the directions contained in the judgment of this court dated 5 January 2024 have been duly complied with. However, the issue as to whether the advance increments should be granted at every
Stage of the ACP.
every ACP stage was placed before the committee of judges of the High Court but could not be resolved. Hence, an application for clarification has been filed before this court. Full stop. Both the learned amicus curiae and Mr. Gaurav Banerjee, appearing for the judicial services, both the amicus curiae, Mr. K. Parmeshwar and
BK Sharma, I am appearing for the
on
judicial
behalf
officer.
of the judicial service associations, state that this is an issue which concerns other states as well. Full stop. They have agreed to, they have stated that they would prepare a compilation of the position as of the manner in which implementation has taken place of the directions contained in paragraph 43 of the judgment dated 5 January 2024, so that comprehensive directions pan India can be issued. Full stop. The issue in regard to the payment of the advance increments for higher education allowance as regards the state of Nagaland is therefore deferred and would be dealt with on a pan India basis subsequently.
Obliged, Your Lordship.
Alan, may I just clarify?
Right. So now,
Apart from ACP for post-graduation also, for a promotion also it has been
It
still
will be covered by
the same
it will
ACP.
be
has
covered by the
been-
same
It will be
order.
covered by this order.
Your Lordship, the
But Miss, we are prima facie of the view that this must be granted at every ACP stage also. It was not like a one-time
Yes.
one-time incentive.
But now for promotion also it has been stopped for Nagaland state.
We'll see. Promotion you have stopped.
Stopped it.
Your Lordship, yes, we're just,
That
we've
we'll
just
resolve.
given one time
Doesn't
and that
matter,
is
we'll
about.
resolve it in a short order. It's not a very major thing.
Obliged, Your Lordship.
Now what is
Your
left
Lordship,
is only
The
Now
chief
what-
secretary and the finance commissioner are also
Yes,
present.
Expensive, yes.
Obliged.
Because Meghalaya is done, Himachal is done, but what is left is Haryana. Haryana, only one aspect, let's para 60 at page 14. The state of Haryana in its affidavit dated 20th August 24 had stated that it has issued necessary GOs revising pay, pension and allowances. The affidavit stated the following. Further stated that domestic help allowance, medical allowance, your lordship will kindly note that, are not extended by the state government to any new pension scheme retirees. So what they did, so far as all the other concerns are, conditions are concerned, they have met, pay, pension, areas, all that has been met. But these two allowances, they are saying if judges start retiring under the new pension scheme, they will neither be entitled to medical allowance nor will be entitled to domestic help allowance.
Mr. Perin, we have to grant this. What is this?
Minutes, as far as this part is concerned, minutes, my instructions are minutes, because this issue specifically, minutes, this is pending consideration because minutes, old pension scheme, whether
But this is independent.
minutes, we are already giving it to all the serving judicial officers. We are giving it to the retirees under the old pension scheme. As far as the retirees under the NPS minutes, for that thing only minutes, there is a little ambiguity minutes. With respect to this minutes, we are saying that whether they will fall.
No other state has this problem.
Who will keep pending?
My lords may decide this issue one way or the other. This
We'll
whole-
decide it with the.
Yes, my lord may decide this one.
We'll decide this issue with the
quickly.
pension scheme.
Please, madam, please.
The state of Haryana, in its affidavit dated 20 August 2024, has stated that it has issued GOs for revising pay, pension and allowances. The affidavit, however, indicates as follows. Para 60 में copy कर लो. We take on record the assurance that all other allowances, except for the domestic help allowance and medical allowance, have been paid.
Please, madam.
They've been paid, no?
Yes, madam. Even the old pensions, retirees under old pension scheme, they have also been.
What stated that the retirees under the old pension scheme have been paid the domestic help allowance and medical allowance also.
Please, madam.
Stop. The issue, however, pertains only to retirees under the new pension scheme. Since the issue in regard to the applicability of the new pension scheme is pending before this court, we defer further consideration of this aspect.
In fact, I just wanted to add something in that
Yeah.
regard. The new pension scheme has now acquired certain dimension.
We saw
So
the
that
other day.
you'll not defer it for the time being so that none of those issues are taken up.
My lord, we,
Very
my
well.
lord may decide this issue of old pension scheme
That's all
in
right.
one
That's-
way so that, my lord, this is decided.
Right.
I don't think this tweaking will really help. My lord.
All right. So now that is Haryana. Now
On compliance,
Orissa is compliance is over.
all is done.
Now we have to, yes, the appearance is dispensed with, no
Okay.
difficulty.
So far,
Now-
I just wanted to point out that Petty Commission recommendation came in 1999. 2007 is when 99% compliance was recorded. We are much better in terms of the record. 22, your lordships accepted the first set of recommendations. In 24, we are at least 95% compliant. Petty Commission took 99 to 2007, one after the other, coaxing the states into complying with the recommendations your lordships approved. It took 8 years then. The second NJPC has taken much lesser time,
Yes.
2 years time.
Now, what are the general directions that we have to issue? We will say that so the present order has dealt with the issue of compliance with the directions contained in the order dated 4 January 2024 and the previous orders. Full stop. Apart from the above directions, we issue the following general directions, bracket 1. In the event that any individual grievances subsist of judicial officers in any state, this may be brought to the attention of the committees of the judges of the High Court, constituted in pursuance of the order dated 4 January 2024. That's one.
In respect of specific allowances, there are disputes that may go to the committee. There are specific allowances partly implemented, not implemented.
This one above, the direction in one above would also cover any grievances in respect of specific allowances, which should be resolved at the level of the state duty concerned by the committee of judges.
So far as the problems that our judicial officers are facing in terms of withdrawal, etc., your lordships had issued specific directions in para 85 and 86 of the judgment dated 4/1/24. Your lordships will say that the high courts will make that compliant, because your lordships have directed them to have standard operating procedures, put it on the website, say how well they can medical
paragraphs
85 and 86. Those directions, your lordship will just reiterate.
High Court, the committees of judges in the High Courts, constituted in pursuance of the order dated 4 January 2024, shall in particular ensure that a standard operating procedure, as mandated in paragraphs 85 and 86 of the order, is duly put into place in any event by 30th September 2020.
You said that your lordships will direct them to meet at least once a month or a fortnight.
The fourth, in order to resolve all pending issues in regard to the payment pending issues pertaining to the grievances of the officers, any subsisting issues regarding the grievances of the officers in regard to the payment of allowances, we request the committees constituted by the High Courts to meet once every month so that the grievances are resolved expeditiously. I think we'll say once every month.
My lord, I filed an application seeking your lordship's permission to recommend to the government for increasing the retirement age to 61.
Should we get into that? You can always do that, but it requires us to give you liberty.
Because of the
what will happen is, as far as Telangana is concerned, it's retirement age to 61. The government employees age was increased from 60 to 61 in Telangana. So the High Court sat with the government, and the government an application before your lordships and saying that the judicial officer
in
Telangana. But that was with the concurrence of the government. The High Court, the judicial officers, and the government was dialogue, because and your lordship also agreed to it immediately.
I remember that order.
Although this commission had said that it's not going to recommend any increase in retirement age,
because the government was willing to do it.
Now there seems to be some concern for the state government.
My lords, may I just take a minute to point out for the state?
They have also increased it for their employees from 60 to 61.
In Andhra.
Question is whether that increase also must, the benefit of the increase must also given to judicial officers. There are two reasons why it ideally should be. One, at the district judge cadre, we are now facing an extreme crunch. We don't get enough officers every year for recruitment across your lordship's knows that. Two, all the special courts that the different statutes mandate are all district judges. POCSO, CBI, politicians' courts, MPs, MLAs courts are all manned by district judges. So it is something that will actually benefit the system if we increase the retirement age by a year.
There's no reason why the High Court should not take it up with the state.
So the High Court agrees with it. The question is whether the state will now agree with it. Your lordship.
My lords, we have no problem.
Whether the state requested us to send a recommendation.
My lords, if I may explain what has happened. The state had carried out an amendment and increased from 60 to 62. That was set aside by the Honorable High Court in light of my lord's judgment. My lords, therefore, now, as of now, the age is 60. If my lord, for the retirement of judicial officers. My lords, if my lords consider the application of the High Court may approach us and we will consider it in due course. My lords, it is a policy decision and a legislative amendment which must be carried out.
The High Court
You are appearing for the High Court?
Yes.
But why did we set aside the decision of the government to increase it from 60
No,
to?
that's for the,
60 to 60.
that's for the civil service, not for the judicial office.
No, my lords, no. For judicial officers, it was increased from 60 to 62. Vijay, an order dated 16/9/22. The Honorable High Court, relying on my lord's judgment in the 4th All India Judges case, says 62 due to hierarchy of courts. The retirement of a district judge at 62 is not permissible. Whereupon Telangana carried out an amendment, made it 61. High Court approached pursuant to the amendment. In Andhra, there is no 61 amendment, which is why
So
the
now, therefore, there's really nothing, okay.
Pending there.
The High Court can certainly approach the government of
Yes,
Andhra to increase it from 60
The
to
state
61.
government asked the High Court to send a recommendation for amendment.
Right.
Now, because of the judgment of your lordships, the High Court thought it fit to seek permission of your lordships.
We
to send
quashed the increase from 60 to 62, right?
Yes, ma'am.
Does our judgment prevent the government and the High Court from, the government from increasing it from 60 to 61?
No, my lords, in the state of Telangana, that amendment has been upheld by my lords. In state of Andhra, that amendment has yet to be done. We are only asking that the matter may take its due course in amendment. We may be permitted to consider it, my lords.
Your lordship,
Why do you require us to give you a stamp of approval? Let the High Court do it, the Chief Justice is to do it.
your lordship only say that the High Court may send.
Why should we, something that the Chief Justice themselves have to do? Why do you have to be so?
Because the judgment of your lordships, my lords, in the All India Judges Association
Look,
says
that said that 62,
from 60 to
60 from 60 to 62,
My
because
lord.
there has to be some difference to be maintained.
My lord,
Now, 60 to 61
Telangana.
is affected in the case of Telangana. That has the imprimatur not only of the states and the high courts, but our imprimatur also. Now, if similarly for Andhra, if you want to submit a proposal to the state of Andhra Pradesh, please do it. Please tell Justice Thakur to send it across to the state government. We have no difficulty. But you don't require, I don't see why we have to certify that you can do it. Do it. Who's going to oppose it? It can be the state government. It can be the judicial officers. So long as it is something short of 62, why should we stand in the way? Especially because the Telangana judicial officers have got it. Right?
arose because of your lordship saying.
That's all right. Now there's no confusion. Have a word with the learned Chief Justice. All right. You can show him the order which was passed for Telangana. Ma'am, why don't you do this? Just share the order which was passed for Telangana with the learned Registrar General.
We will do it, my lords. However, they are aware of it. And they are aware that
He
it's
knows
supposed
it.
to
You don't
legislative.
require us to. All right. So this part is over now.
Because only this part is over, Millet. Today also, your lordship had listed the suo moto so far as the High Court judges' salaries and the fixation of High Court, a number of issues. So I have just put in a note, Millet. Some of those.
Do we take it up today or do we take it up?
Lordship will just adjourn these matters because pleadings are not complete.
All.
Just kindly takes the note for a minute, Millet. There is a horizon. I've just made it easier and put one vertical and one horizontal.
Yes.
Well, this is an entire batch of matters connected with the suo moto. On the last occasion, your lordship had issued notice on the suo moto. There are 3 matters in which I have indicated notice as formal notice has not gone, pleadings are not complete. Your lordships will direct.
Which are those?
Item number 5.
5.
7.
And
15.
5 is refixation. 7 is Hate Singh. Right?
Right.
That's Hate Singh Yadav.
That's right.
And 15 is refixation of pension, additional pension.
Right.
So we'll issue notice. They are on board today, right?
They're all on board today.
We'll issue notice. Returnable on Kato. Counter after 2 weeks.
4 weeks. Let the
4
pleadings
weeks,
also be
Karo.
complete. Let the pleadings also be completed, then we'll.
Pleadings be completed in the meantime.
This can be detached from the All India judges because this is High Court
Just
pension.
detag this. These are High Court pension matters. All right. And detag it and we list it separately.
There are 2 employees matters which have also come in the list today. That also will be detagged and your lordship can call it.
Can you just give him the
We'll give the numbers. We'll give the numbers.
employees matters detag kar do, wo alag list hai.
1.8 actually.
We'll take it up.
Looking for a very long time.
Yeah, we'll take it up.
Yes.
All right.
Grateful.
Your lordship.
There is 1.17.
That is in this one. The High Court judges fix it.
1.2.
This is also the High Court judges in the same batch. What Mr. Dwivedi is appearing in. This is
1.17, no, it's a pension matter, my lord, just claiming the benefit of the judgment of the lordship already delivered, my lord,
again, High
Rahul
Court
Garg's
judges.
case.
High Court judges, my lord. Because there are three or
Notice
four.
has been issued in that matter?
Yes, notice was issued.
Because the union is contesting, there are 3 or 4 sets of matters in the High Court judges case. One, additional judges who were not made permanent, died in office, family is not getting pension, number 1. Additional judges, if they don't complete the requisite qualification as of qualifying years of service as a High Court judge, whether they are entitled to pension at all, issue number 2. District judges who are under the new scheme, new pension scheme going as High Court judges, which is the lead matter your lordship took so motor cognizance of, because he was not entitled, the gentleman there was not entitled to pension as a district judge because he was under the new scheme, and he became a High Court judge. Even after retirement as a High Court judge, they are giving him the same new pension scheme pension and not the pension that otherwise High Court judges are entitled to. So there are 6 or 7 issues. I have tabulated them, in each one. What is the issue? Your lordships will have it because the union is contesting each one of them.
No. In my case, it's squarely covered by the judgment. There's no question of contest in this case. It's on all 4.
I know, but we'll have to hear the other side, right?
The union.
Who's appearing for the union?
My lord, may I need 30 seconds, my lord? My lord, may allow me 30 seconds, my lord?
Your
My
lordship
lord, may
have
allow me 30 seconds, my lord?
Lordships have interpreted part 3. We are claiming this benefit as interpreted by lordships. The other thing your lordship
Can
said.
we detag that matter and then hear that? Then just detag that and keep it on another day, on a Friday. We'll see then, so we doesn't get lost in this big bunch.
Only 4 paragraphs your lordship judgment have to pay.
We'll keep it either on next Monday or something.
May I seek my lordship permission, my lord? To mention item number 1.2 to 1.6, my lord. In one of them, Lord, the petition of R.P. Mishra, my lord, who is not getting salary for the last 9 months. He's a sitting judge of Patna High Court, my lord.
Right. We are keeping all of them together, and we'll keep it because there are some matters where notice was not issued. We'll hear it together in 4 weeks and resolve it.
My lord, what is happening is he's not getting salary for the last 10 months, my lord.
Same problem, salaries.
He's a sitting judge of the Patna High Court, my lord.
The concern is this: they are saying he does not have a GPF account. Therefore, he is not entitled to salary. It's a very weird case, Mullah. They are saying these are officers who are under the new pension scheme. They are working
Besides that new pension scheme, straight away all this will be over, my lord.
Because they are saying because these are sitting judges, judicial officers who were born into the new pension scheme. They don't have a GPF account. Therefore, we will not transfer salaries also. This is a sitting judge of the Patna High.
What?
Once your lordship decides that matter, all this will fall through.
Who's appearing for the Union of India? We'll take it up separately in another. We'll keep it up, dealing this matter, just Mishra's matter, and we'll take it up either on Friday or Monday. We'll take it up.
It will take only 1 minute, Lord. If you Lord take, my lord. Only my lordship may see page number 63 and 64.
Who are you appearing for?
For R.P. Mishra, my lord. Justice R.P. Mishra.
We are taking it up. We'll take it up. We are not keeping it in the group. We'll take it up next Monday for Justice R.B. Mishra's matter. And who is appearing for the Union of India?
My lords, I'm here. Learned Attorney General was leading us, my lords.
Right. We ask him to be here next Monday. We'll take it up.
There are lot judges. I'll give the numbers of all 3 judges who are sitting judges who are not being denied salary because of this issue.
Your lordship, one more I.
Not receiving salary?
My lord, I need 30 seconds, my lord.
Vested is not of
My
pension.
lord, may allow 30 seconds.
Because you were born into a cadre which did not have a assured old pension scheme. You don't have a GPF account. Our software does not provide for giving salaries to a person who does. That is what I am saying. This is
it's for Friday. We'll take it up this Friday.
Very well.
Your lordship.
Take it up.
One more.
Because tomorrow, Wednesday, Thursday, we are in a CB. We'll take it up on Friday.
Your lordship's one more application. I am not getting pension since 2014. Notice has been issued. That also may be tagged along with this.
No, that's the district. That's all India judges.
That's an all India judges. These High Court judges, we'll take it up on Friday. Let's at least start clearing. Otherwise, if everybody asks for tagging, nothing gets disposed of. At least let's deal with these 2 matters, Mr. Dwivedi's matter and this matter. We'll deal with it this Friday, and then we'll see how best to move forward.
My lord, fixing some date for
timetable. You can look at it then.
Deeply obliged.
May I circulate a 3-page note, my lord?
Yes, please, that will be, on that day you can give it to us.
In that case, my lordship may direct, my lord, that item number 1.3, 1.2, 1.3 and 1.5, my lordship may be taken on Friday, my lord, because all pertains to the judges of the Patna, sitting judges of the Patna High Court and Allahabad High Court.
All right.
1.2, 1.3 and 1.5. I'm grateful.
1.19 to 1.19.
What is that?
I'm appealing in 1.20.
What is that?
That is also retired judges.
Parmeshwar, what are those matters?
Those matters are, there is a
From Madhya Pradesh.
fixation of pension for those judges who came from the district judiciary into the High Court. Their pension is now fixed lower than the judges who are elevated from the bar. Who are elevated from the bar because the same concern, this old pension, new pension scheme. So at some point of time, because your lordship will decide that old pension, new pension scheme, then all this will fall into place. Essentially, my lords, in all these petitions, the argument is for one rank, one pension. Whether you have served as a High Court judge, doesn't matter from what rank you
become
came.
a High Court judge, you must get the same.
You are entitled to the same pension as any of your colleagues are concerned. That essentially, if you're, that's a short point. If that point is decided, let's
that up also immediately.
That is item number 1.15 also, my lord. The same, my lord, the district judicial.
Ek hi kar lo. Keep
I will give the list, Millers. I'll give
just
the
give
list.
the list. Parmeshwar will give it. But make sure you keep Mr. Dwivedi's matter and RB Mishra's matter first and second. We'll at least take it up, then open the others.
That's 1.15. I'm appearing for the CAG. There's a gap. There's a gap between the service before got promoted.
There can't be a difference in pensions of two people born in the same cadre. Can't be that some High Court judges get one pension, other High Court judges get another pension.
Already covered by my lord's judgment on the Rahul.
I'm going to start number 3, no? You just take up.
My lord, I'm brief for 30 seconds, my lord. My lord, in the Kerala, my lord, the state has issued a notification. Whatever you were getting on 31st December 2015, that would be multiplied by 2.81, my lord. This is not correct, my lord, because that payment has to be revised. They have not done it, my lord.
Committee.
This is one thing, my lord.
It's for the allowances.
No, pay.
My lord, pension, my lord.
Why, have you taken it to the committee of judges?
My lord, your order.
My lord,
because, otherwise 32 will become what? Look at, we have spent 2 hours in the morning only doing this on a Monday. That's why we've institutionalized it. Leave something for the committee of judges in the High Court. They are right there. They should be taking this up.
we have given that representation, my lord. Thereafter, we have filed a contempt petition, my lord. My lord has directed the chief secretary to come, my lord. That has been disposed of. But this is the fact, my lord. This is for the Kerala, my lord. And then, my lord, Jammu and Kashmir, my lord. Jammu and Kashmir has notified 1996, my lord.
Why don't you go to the committee of the High Court and have them look at it? That's why we institutionalize the process. Everything for every individual state, if we start dealing with these individual grievances, it's impossible for us to. Ordinarily, you have to file a 226 petition. Now, just because there's some petition pending, everybody comes with IAs. We have therefore institutionalized the process by constituting committees of judges in the High Court. Surely, there has to be some faith in those committees. We have said we'll meet at least once a month.
My lord, the committee.
All right, we'll just rise for 5 minutes. We'll take up skill number 3.
Just one, sorry. I'm very sorry. Item 2 has been wrongly tagged with item 1. It has something to do with pay revision of the staff of the High Court, which is at par with the Secretariat.
So 2 has to be delayed.
And it is the admitted matter of 2017. Lord.
2 has to be delayed.
2 has to be detagged. Lord. It's my respect.
Yes.
Where you like.
No.
I may just make a prayer, my lord.